For me, this is a culmination. This thing of customary land tenure, which now we're talking about registration. For me, I am ahead of all of you. You are my converts. So I'm speaking to a convert. I represented what is now Agago district in the 1994-95 Constituent Assembly deliberations. And when I was campaigning here, and some of the people are here, they know what I was telling them. I told them that the constitution of Uganda will be like many other constitutions in the world. There are provisions you find in all constitutions. They may be worded differently, but they're the same. I told them my purpose for accepting to go to the Constituent Assembly were two. One, land. Two, multi-party democracy. By that time, you will want to know that the livestock census for 1985-86 at place Agago County, it was not yet a district. It had 53,000 head of cattle. 53,000. After there were more cattle in Agago County than the whole of West Acholi, which now comprises Bulu, Bulu City, Omoro, Nuoya, and Amoro. The livestock there, the number of cattle there combined was still below what we have here. In 1988, the next time there was a census following the Peche peace accord in 1988, the cattle population in Agago had dropped to 460. 460. 3 digits. From 53,000, 5 digits, 53,000, it had come down to 460. Mainly Karamojong raids. That one was not now raiding. That was just plutocracy, just coming to loot, to take at will. And the backbone of the economy of this place was livestock. Some of us went to the best schools in Uganda because of livestock, not cotton. Actually, the cotton economy in northern Uganda, was speaking about this, was the reason why northern Uganda lagged behind. Northern Uganda has not lagged behind only now. It has only worsened now. The war and the other things have only exacerbated northern Uganda is lagging behind. So my purpose for going to the Constituent Assembly was to deal with customary land tenure. And as a lawyer, I knew this, and I told my potential voters in 1994. When the British colonialists came, your people also had customary land in Buganda. You had customary land. But by the stroke of a pen, the British colonialists came, and those who supported them against Bunyoro and the Kakonglus and the other generals, they were rewarded with square miles of land, which is known as Milo, Tenua or Milo time. Square miles in Buganda, in Bunyoro, going to Toro. Elsewhere in Uganda, and let me speak about the Acholi sub-region or northern Uganda, they did not introduce Milo titles. The whole of this land was crown land. So if in England it was a king, in power, the land belongs to the king. If it was a queen, like when King George, during the Second World War before, when King George was in power, the land belonged to King George. When his mother, Queen Victoria, the colonialists, during the time of Queen Victoria, Queen Victoria was the owner of the land, including where we are standing. It was crown land. The sad thing, because it was crown land by name, my grandfather, whom I never saw, my father believed he was on land which he owned. They would say ancestral land, Mwampwara. He had no ownership of that land. He was not even a squatter. He was not even a tenant. He was a licensee. A licensee is somebody who is just there. You license, say, okay, you can use, tomorrow you can say, please leave. You don't have to give notice of 2 months, 3 months. That was the state of the land in the bulk of Uganda. Northern, eastern, where there was no Milo. What did Milo bring where it was applied? By the stroke of a pen, when the sun, yesterday when you went to sleep, you were still the owner of the land. You wake up, you find that the governor had signed the document. Now you are the landlord above you. You are now a Chibanja holder. Somebody you don't know is the owner of the land which belongs to your ancestors. That's what happened. Here, we were deceived. We thought we had the land. Now, people started discovering that they did not have the land. Because one, when we got independence, 1962 Constitution, instead of giving this land back to the people, crown land became public land. It was never given back to my father. Actually, my father owned this land for 1 year because he died in 1996. He owned land for 1 year only. So, the 1966 Pigeonhole Constitution maintained public land. That was in the hand of government vested in the Uganda Land Commission. 1967 Republican Constitution maintained the same thing. The 1969 Public Lands Act and the rules made under that act maintained the provisions of the Constitution. What did the 1969 Act, Public Lands Act and the rules say? That's when people now began discovering that they did not own the land. The land, you say, my grandfather, I inherited from my ancestors. Now, you are able to come and talk to the people here that please allow investors, under that law, in independent Uganda, this investor would come here, look at these mountains, look in the other direction, and say, I want to breed flies here. Just breed flies. I say, okay, fine. Then they find a whole clan in the area. They say, this one wants to breed flies here. He's an investor. We'll make money out of him. Our tax price will be richer. Now, you are going to be compensated, not for the land. How many mango trees do you have in your compound? Papaya trees? How many grass thatch houses? How many semi-permanent? They didn't have permanent. If you had mud and water building, you were a very rich man. That was called development. The development you put on the land is what you'd be paid for. So the word was compensation. And the rules, you people can get the rules for you. Where is Mr. Bo? Mr. Bo? Yeah, get it for the minister so that the minister can understand. The Public Lands Act of 1969 and the rules. Some of those things, those trees were 2 shillings. I don't remember now the details. So the moment they pay you that money, you're given 6 months to relocate. You find land elsewhere. So that was the fate of land here, which our people erroneously called their land. Our people had no land. For me, I saw that the Constituent Assembly was an opportunity to correct this wrong. And my personal view was to correct the wrong of having somebody with a Milo title that has never used the land, because there are Bibanja holders all over the land. He has a Milo title, the Bibanja holders do not have a title. They cannot use that land for economic purpose in terms of going to the bank or financial institutions. But the fellow who has got a Milo title also cannot. If there's a transfer, is given a kanzu, and that's all that means. So for me, and I chose Select Committee 1, which discussed the land question. And I chaired the land question. So when I introduce, you need to know this background. When I say this is a grand opportunity to lift our people away from being licensees on their own land, to bring them as the ultimate owner, so that the customary land owner is at par with the Milo land owner, with the Frio land owner. It was something strange. My first two converts were the late Dr. Okule Bak, God save his soul. Another one is still alive, Professor Kanyehamba. Those were the first two who understood me. Because the Justice Odoke report and the draft constitution wanted a continuation of public land where we would remain here without land, deceiving ourselves that way.